Good morning. Just the three of us on here right now, but I wanted to let you know that just so you're aware of what's going on. But first of all, my name is Mark Velosh. I'm the Deputy Secretary of State for Elections. Good morning. Thank you for joining us. In a few minutes here, we'll wait and see if other people join. There's a 2-hour delay across the state today, at least in Northern Nevada, but we intended to keep this on schedule simply so that folks down south and across the state are able to participate. But we'll see who joins. I'll mute it now and we'll kind of keep an eye out for who's attending. Thank you, though. All right. Good morning, ladies and gentlemen. My name is Mark Velosh. I'm the Deputy Secretary of State for Elections. I've got 801, but it looks like there's still a handful of people that are trying to join. So I'm going to drag my feet a little bit in the interest of, again, trying to encourage as much participation as possible. So I'll plan on starting at 8:05 to see if maybe there's a handful more individuals that are able to join to participate. But that's what's going on. So I'm going to mute and then we'll plan on right at 8:05 kicking it off. But thank you for joining us this morning. Good morning, Elizabeth. We were just waiting a few minutes. Can you hear me all right? Excellent. Okay. For those of you that are just joining us, again, good morning. My name is Mark Vlosh. I'm the Deputy Secretary of State for Elections. In the interest of getting as many people to participate as possible, we're going to wait a few more minutes. I do have 8:05 right now, though. It does look like this may be it. But again, I do appreciate everybody joining us this morning. And we'll go ahead and get ready to kick this off. Okay, I don't see anybody else trying to join, so we will start this off. Good morning. I'm calling this regulations adoption hearing to order at 8:05 a.m. For the record, I am Mark Voloshin, Deputy Secretary of State for Elections, and I will be conducting this adoption hearing today. Before we begin, I would like to clarify a few things. Our discussion today during this adoption hearing will be focused on the proposed regulations listed in the agenda. We should not discuss changing statutes, which are, of course, created by the legislature. This regulatory process will not alter any existing laws. This adoption hearing is not the end of the regulations process. Following the completion of this adoption hearing today, the next step is the Legislative Commission on February 28th at 1 p.m. I'm going to copy a link into the chat right now that will take you to the Legislative Commission website that will provide the meeting information when it is available. Perfect. Okay, just did, and I confirmed that the link works. If it doesn't work on Internet Explorer, you may have to open it in Chrome or another internet display web browser, excuse me. But you'll see at the top of that page, it does have Monday, February 28th at 1 p.m. It does currently say the agenda is not yet available, but that's where the connection info will be for that meeting. Regarding the adoption hearing today, and as a reminder, there are 3 ways to indicate you wish to make a public comment. First, you can click on the raise hand icon, which is in your Zoom bar. If you go down to reactions, the little smiley face with the plus sign, or you may need to go to the more button, you'll notice that there's an icon you can click that for raising your hand. When you click it, just as how I did, you'll see in the top corner of your picture, a little raise hand icon will appear. I simply ask that you lower your hand upon completion of your time to talk, so that way we can tell who's still interested in providing public comment. So that's the first way. The second way, a little bit old school, but you can physically raise your hand in your camera if you don't want to mess with the icons. Or you can possibly state in the chat as well, the third way, that you would like to make a comment. If possible, please, again, just identify that you would like to make a public comment in the chat, and then we will provide you an opportunity to speak. In lieu of asking the question in the chat itself. If there are general questions about elections procedures today, I'll be happy to discuss them as long as they relate to the proposed regulation. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at nvelect@sos.nv.gov. I will copy that link into the chat as well. Finally, participants in this adoption hearing are reminded to treat one another with dignity and respect. This includes in the use of the chat, which is primarily intended to enable participants to indicate that they wish to make a public comment. This is the adoption hearing for Secretary of State Elections Division's proposed regulations with the following LCB file numbers: R087-21P, R088-21P, R089-21P, R090-21P, R091-21P, R092-21P, R093-21P, R094-21P, R095-21P, R096-21P, R097-21P, R098-21P, and R111-21P. The draft text of all proposed regulations has been provided, as are the statements required pursuant to NRS 233B.0603. The notice of intent to act upon a regulation was originally noticed at all required locations on January 19th of 2022. The updated notice was posted on all required locations on February 15th of 2022. The updated notice merely added on that bottom regulation R111-21P. Workshops were held to solicit public comment on January 19th, 2022 and February 4th, 2022. Since then, the Secretary of State has continued to receive written feedback relating to the proposed regulations that we will discuss today. I will address some, but not every one of the proposed suggestions and comments received. Some of the suggestions have been incorporated into these proposed regulations. In those cases, the amended text will be described, but the final version of the text will be available prior to the Legislative Commission on February 28th. Other suggestions will require further research and analysis over the coming months, but may be considered for future regulations following the 2022 election cycle. Some suggestions conflicted with existing statutes or exceeded the scope of these regulations and were not considered. Finally, the Secretary of State had a number of requirements to weigh in the consideration of the provided public comments. These proposed regulations were drafted in order to 1, update the regulations as required by NRS 233B.050, 2, to clarify expectations for the clerks and registrars, and 3, to increase transparency for the public. While many of these proposed regulations create additional requirements for the clerks, registrars, and secretaries of state staff, it's important to recognize that the work required by our state and county election officials has increased in the last few years, and there are no good metrics upon which to base future requirements. The 2020 election cycle was unique and had a number of factors that directly affected voter turnout and clerk and staff requirements. Many of the issues present in 2020 are not the same in 2022. For example, the state received $4.5 million in CARES Act funding to support the additional needs of the 2020 election cycle. Those funds are no longer available. Therefore, we do not have a clear precedent to look to for future election cycles. Altering these proposed regulations to make them more stringent or to increase requirements beyond what are laid out in these proposed regulations could make them impossible to accomplish. Therefore, in many cases, we are moving forward with these measured, reasonable improvements, but with an eye on future modifications that will be based on lessons learned during the 2022 election cycle. Okay, at this point, we are on the next agenda item, public comment on matters other than the previously listed LCB file numbers. The comments will be limited to 2 minutes per person. At this time, is anyone interested in providing public comment about a matter not on the agenda? If so, please identify yourself and spell your name for the record. And to be clear, I would ask that you do that going forward as well for the duration of our hearing this morning. When it's your turn, please state your name for the record so I can make sure I copy it down properly and we can read it into the record. At this time, is there anybody interested in making public comment on a matter not related to an item on the agenda? Good morning, Elizabeth, please.
Good morning, Mark. I have a general comment on this
I'm sorry,
entire.
can you say your first and last name?
Oh, sorry, Elizabeth Hammock, my bad. I feel like the temporary emergency overall has led to many important things leading towards policy changes. And I just want to state that I feel that any machine voting and any mail-in voting that is not individually requested opens us up to fraud, duplicate votes, deceased votes, non-citizen votes, more votes than are registered. And I realize you're trying to make some changes here that are trying to limit some of that fraud. But the reality of it is that on the Secretary of State site, people actually have to opt out of mail-in voting. And how many people do you really think know about that? Not many. So the reality of it is that a lot of things need to be changed, but the mail-in should never become a permanent change, especially when it started from a temporary emergency. Thank you.
Yes, ma'am. Thank you for your comment. At this time, is there anyone else interested in making a public comment about a matter not on the agenda? Okay, seeing no other hands. All right, we'll close public comment on matters not relating to items on the agenda, and we'll move on in our onto the regulations. All right, at this time, I will open the adoption hearing regarding proposed amendment R087-21P. And just so that, again, we're all on the same page, what I'll start by doing is, again, reading the legislative digest explaining what this proposed regulation does. If there were changes or public comment or feedback, and again, most of these cases there were, I'll describe some of the feedback we received along with, again, some of the considerations that we are taking into account. If there are changes to the text that have been approved, what I will do is, again, I'll read that into the record at this time as well to make sure that everyone is very clear on what those changes will be before moving on to public comment. All right, so this time we'll start with proposed regulation R087-21P. Existing law provides, make sure I'm not on mute. Okay. Existing law provides that in order for a mail ballot to be counted for any election, the ballot must be 1, delivered by hand before the time set for the closing of the polls, or 2, mailed to the county or city clerk as applicable. If a mail ballot is mailed to the county or city clerk, the mail ballot must 1, be postmarked on or before the day of the election, and 2, received by the clerk not later than 5 p.m. on the 4th day following the election. Existing law provides that if a county or city clerk determines when checking the signature used for the mail ballot that 1, the voter failed to affix his or her signature or failed to affix it in the manner required by law, or 2, there's a reasonable question of fact as to whether the signature matches the signature of the voter, the clerk must contact the voter and advise the voter of the procedures to provide a signature or confirmation that the signature used belongs to the voter as applicable. For the mail ballot to be counted, the voter must provide a signature or confirmation as applicable not later than 5 p.m. on the 6th day following the election. This regulation provides that if any such deadline falls on a legal holiday, the deadline is extended until 5 p.m. on the next working day. Now, as mentioned, again, there was significant feedback across the board on all the regulations we're going to discuss today. In general, though, the feedback received relating specifically to this proposed regulation was simply to not move forward on it. But again, based on that, we are, though, going to move forward on it without changes to the text, given the importance of clarifying what happens if it falls on a legal holiday, which actually is coming up here within the next couple election cycles. Okay, this time I'm going to open public comment on proposed regulation R087-21P. If anybody wishes to speak specifically or provide feedback relating to R087-21P, please go ahead and indicate so in Zoom now. Ms. Hammock, do you have a comment on proposed regulation R087-21P?
No, I don't. Do I still have my hand raised?
Yes, ma'am.
Let me take that.
Certainly. Okay, I do not see anybody interested in providing public comment on proposed regulation R087-21P. Okay, hearing no further public comment, I will close public comment on proposed regulation R087-21P and proposed regulation with LCB file number R087-21P is adopted and will move forward to the Legislative Commission. And to clarify that there's a couple options that can occur here today that at the end of the public comment part, just so we're all on the same page again in regards to what this process will look like. I'll explain the changes. I'll read the legislative digest. We'll go to public comment. If there's no public comment, or again, if there is some public comment, we'll discuss the proposed regulation. And then after I clarify for the record what those changes might be, I'll read it into the record. And really, again, it's moving forward to the Legislative Commission after it's adopted is really the next big step. Though in previous adoption workshops, we have not moved forward on certain adoption of regulations. So that's a possibility as well. But in this case, again, regulation LCB file number R087-21P is adopted and we'll move forward to the Legislative Commission. Okay, this time I will open the adoption hearing on proposed regulation R088-21P. Existing law authorizes, under certain circumstances, a person to cast a provisional ballot if the person registers to vote in person or updates his or her voter registration information as applicable at a polling place. Existing law further authorizes a person to cast a provisional ballot if the person completes a written affirmation and 1, declares that he or she is registered to vote and is eligible to vote in the election in that jurisdiction, but his or her name does not appear on the voter registration list. 2, has registered to vote by mail or computer, has not voted in an election for federal office in the state, and fails to provide identification to an election board officer at the polling place. Or 3, declares that he or she is entitled to vote after the polling place would close as a result of certain court orders. Existing regulations set forth various provisions related to the latter type of provisional ballot. Sections 1, 6, and 7 of this regulation define the term provisional ballot for purposes of these sections to clarify the provisions apply only to the latter type of provisional ballot. Existing regulations require the Secretary of State to send each county clerk a written notice designating the offices for which candidate are to be nominated in a primary election, requires each county clerk to publish the notice in a newspaper in his or her county within 10 days of receipt. Section 2 of this regulation requires the Secretary of State to also 1, send an electronic notice to each county clerk, and 2, post a copy of the notice on the website of the Secretary of State. Section 2 further requires the county clerk to publish the notice on the internet website of the county clerk and provides that if the county clerk is unable to publish the notice in a newspaper within 10 days due to the publishing deadlines of the newspaper, the county clerk must publish the notice as soon as possible. Existing regulations set forth the years in which the seats of the offices of Justice of the Supreme Court are to be elected. Section 3 of this regulation updates those years. Sections 4, 5, 14, and 15 of this regulation eliminate obsolete references to an acceptance of candidacy, as that term is no longer used in Nevada-rise statutes. Existing regulations require the county clerk and city clerk to mail at least 5 sample ballots and provide an electronic sample ballot to the Secretary of State. Sections 5 and 16 of this regulation instead require the county and city clerks to provide only an electronic sample ballot to the Secretary of State. That sample ballot, by the way, is again intended for review and again, just maintaining it as a public document. That's the intent behind that one. Existing regulations require each county clerk to submit to the Secretary of State a voting history for each voter in the county who casts a ballot in an election not 45 days after each primary or general election. Section 8 of this regulation instead requires the county clerk to send the voting history not later than 45 days after every election. Existing regulations require certain election complaints to be filed in the office of the Secretary of State in Carson City. Section 9 of this regulation removes the requirement that the complaint be filed in Carson City. Sections 9 to 13 of this regulation update existing citations to Federal Help America Vote Act of 2002. Okay. Now for this, proposed regulation, we did also receive significant feedback. There was a lot of discussion and some really good ideas about how to increase transparency while also increasing the amount of information made available to the public. This is something that we've actually taken into consideration holistically, again, not just relating specifically to this regulation, but something that, again, across the board, we are looking at different ways that we can take information that the county clerks have, get it up to and consolidated at the Secretary of State's office, and then published in a more timely manner. But again, instead of codifying something specifically in this proposed regulation, it's something that we are reviewing holistically and may incorporate into future regulations. As such, there are no proposed changes to this to proposed regulation R088-21P. At this time, is there anybody interested in, at this time, I will open public comment on proposed regulation R088-21P. At this time, is there anybody interested in providing public comment on proposed regulation R088-21P? If so, please go ahead and indicate in Zoom now. Ms. Lee, good morning, please.
Hey, good morning, Ms. Volashin. Pauline Lee, spelled L-E-E. When you were saying that you did receive quite a bit of commentary, but that, are you going to adopt those comments? Are you saying that you are going to put it in these regulations, or that you're going to add them in future regulations? I'm a little bit confused. Could you clarify, please?
Yes, ma'am. Apologize for the confusion. Not in these regulations, but and I believe you may have maybe missed the workshop. So it warrants me saying again, actually, we've realized, and so first to answer your question, not in these regulations, but future regulations. And then the second part is that we've realized through this regulatory process that we've been working on now about 14 months, that this review really needs to be on a really a biennial basis. Not just so that we can make sure that we're updating regulations as appropriate, but so that we're thinking critically about the existing regulations and trying to identify ways that we could improve them. For example, the automatic voter registration regulations, right? We put those in place after ABR went through, but really every year or two, we should go back to consider, are there ways that we can improve those regulations? Are there things that we could do to enhance public transparency and provide additional clarity? So in these sorts of cases, and this regulation is a great example, as we received feedback about different ideas, there were a lot of things that we thought that, man, that'd be really great. But we also, again, going back to my opening comments, we're just not sure at what level the clerks and registrars are going to be taxed given the existing and new requirements following the last legislative session. There's also a lot of discussion about what manner of how are we going to do it, I guess is the best way to say. So there's some ideas that we have and some analysis that we're going to conduct during the 2022 election cycle. And then beginning this coming January, in 11 months, not quite, actually almost 10 months, we're going to begin the regulatory review process again, starting with the notes that we have from this regulatory cycle, and then the lessons learned going through the 2022 election cycle. So that way we can ensure that these regulations don't stagnate and continue to be improved upon. Again, much in part based upon the feedback that we received on these proposed initial regulations. Does that answer your question, ma'am?
And what guarantee do we have that this will be an ongoing process? My worry is that we're going to stop that process based on political factors as opposed to continuing our review of how things are going.
Yes, ma'am. So again, it's very much part of my intent that we're codifying that through our internal processes and procedures. I think you're spot on, though, that there's a number of factors that may change that, in going forward. Secretary Sagaski, of course, terms out, and depending on the new secretary's direction, it may be different. But this is something that our staff collectively has been involved in, is keenly aware of, and clerks are as well. Again, I think we all recognize the merits of this process. So carving out a time, making sure that it's part of our established calendar cycle, and more are all parts of our efforts to make sure that this doesn't stop based on personalities or certain political factors.
Thank you, Mr. Lashin.
Yes, ma'am. At this time, are there any other public comments relating to proposed regulation R088-21P? Okay, hearing no further public comment, proposed regulation, I'll close public comment, and proposed regulation LCB file number R088-21P is adopted and will move forward to the Legislative Commission. I'll now open the adoption hearing on proposed regulation R089-21P. Assembly Bill 321 of the 2021 legislative session repealed existing provisions of law governing voting by absent ballot. Section consistent with the changes made by AB 321, Section 9 of this regulation repeals obsolete regulations relating to voting by absent ballot. Sections 1 to 8 of this regulation eliminate obsolete language related to voting by absent ballot. Okay, in this regard, also, again, there was some feedback that we received, and in further discussion with the clerks, there's one amendment to this proposed regulation. One of the regulations that had been proposed for removal upon further discussion, it still has merit, and again, we're going to amend this regulation to not repeal NAC 293.318. which relates to absent ballots and the plan for disposition in case of emergency. This NAC 293.318, just again for the record, it states each county and clerk and city clerk shall submit a plan to the Secretary of State setting forth the procedures that the clerk will use for the disposition of absent ballots in case of an emergency. Such plan must be submitted no later than 90 days before each election. Such plan must be submitted not later than 90 days before each election. In the case of an emergency, the Secretary of State may order one or more polling places to be used to accommodate voters who are unable to vote at their polling places due to the emergency. As used in paragraph O of subsection 3 of NRS 293-247, emergency means a temporary or permanent situation where one or more polling places located within the jurisdiction of a county clerk or city clerk does not have a mechanical voting device that is properly recording votes electronically. So again, proposed regulation R098-21P will be amended to not repeal NAC 293-318 that I just read. The text of that regulation, again, will be under further review and possibly may just replace the word absent with mail in order to comport with existing law. But again, the intent there is so that, again, this emergency plan requirement is still in place. This is something that, again, while some folks say, well, we don't have absent ballots anymore, why would this still exist? Again, the possibility that we discussed internally and with the clerks was that if a polling location does shut down and there are voters who have possibly opted out and did not receive a mail ballot, again, the goal is to make sure that the clerks have thought through and provided to the Secretary of State a plan that would accommodate those voters to ensure that they could still, cast a ballot appropriately. At this time, though, I will open public comment relating to proposed regulation R089-21P. If anybody's interested in providing public comment on proposed regulation R089-21P, please go ahead and indicate so in Zoom now. Okay, seeing no public comment, I will close public comment, and proposed regulation R089-21P is adopted with the changes as mentioned on the record and will move forward to the Legislative Commission. This time I'll open the adoption hearing on proposed regulation R090-21P. Proposed regulation R090-21P. Existing law requires the county and city clerks to send to each active registered voter and each person who registers to vote or updates his or her voter registration not later than 14 days before an election a mail ballot for all elections. Assembly Bill number 321 of the 2021 legislative session repealed the provisions of Nevada revised statutes relating to absent ballots. Existing regulations, 1, require each county clerk or city clerk to provide with each absent ballot certain instructions for correcting a mistake on the absent ballot, and 2, prohibit the county or city clerk from duplicating an absent ballot unless there is no ambiguity as to the intent of the voter. Section 2 of this regulation sets forth similar requirements for mail ballots. Existing regulations establish certain procedures for processing an absent ballot, including 1, requiring the city or county or city clerk to record the receipt of the absent ballot and check the signature on the return envelope, and 2, the placement of any rejected absent ballots in a separate envelope and the notation of the reason for the rejection. Sections 3 and 11 of this regulation, 1, set forth similar requirements for mail ballots, and 2, require the county and city clerk to keep accurate records of the chain of custody for all mail ballots. Existing regulations establish certain requirements for an absent mail ballot central counting board, including requiring the board to sort and count absent ballots by precinct. Existing regulations further require, with certain exceptions, the county clerk or city clerk to allow members of the public to observe the handling of absent ballots. Sections 4 and 12 of this regulation establish similar provisions for mail ballots. Existing regulations require each county clerk and city clerk to submit a plan to the Secretary of State, setting forth the procedures the clerk will use for the disposition of absent ballots in case of an emergency. Section 5 of this regulation establishes similar requirements for mail ballots. Section 6 of this regulation defines the term mail ballots. Sections 7 and 9, 13, and 14 of this regulation eliminate obsolete references to the term absent ballots and various provisions that will instead apply to mail ballots. And this is 0. On this regulation, there was also a significant amount of feedback that we received. Again, a lot of these things were already under consideration across the state as the clerks and state here consider methods to improve upon the existing processes. But some of the considerations that we've received and are further considering and looking into, again, really conducting an analysis during this 2022 legislative session, or excuse me, 2022 election cycle, comments about clarifying requirements for ballot duplication boards. The idea, and this was something that again came up repeatedly on these regulations, the idea of changing it so instead of bipartisan involvement, having tripartisan involvement and mandating that, not making it as practicable. Other discussion points identified mandating certain activities as allowable for public observation, calling them out specifically. There was some discussion feedback we received in regarding to the public notifications and changing in some cases from the clerks having a requirement to provide details of their schedule from instead of 2 days as it currently states in regulation to 7 days before the date of that activity. More specifically on that one, again, the idea that a mail ballot counting board currently posts their schedule 2 days prior, but proposals to shift that to 7 days were made as well. Discussions about detailed schedules of observation, including start and end times in the office and on the website, so that again, the public is more keenly aware of the specific activities and when they will start and stop. And then also calling out some specific, I guess there's some other specific activities that were requested to be identified by name in this regulation. There was also further discussion on certain terms and providing increased clarity on what it means, for example, to interfere with. So that way there was basically a defined list of activities that would be considered interference. Some of these, again, were already under discussion. Some are being considered for future regulations. The comments about changing the public notification from 2 days to 7 days was one that we looked at, but also ultimately decided wasn't actually realistic or practical, for the simple reason that in many of our counties, again, they don't know when their schedule is going to, when they're going to schedule these boards to convene. In some cases, as you can imagine, the number of mail ballots that arrive aren't enough to gather a group of people together in some cases. So they do the signature verification portion, then they secure the ballots in a vault until they have enough. And when they're about 2 days out is when they historically have scheduled and again announced that activity is going to occur, which is why the 2 days is what it was decided upon originally. And that's the sort of thing that 7 days prior simply wouldn't be known based on the number of ballots received. And again, certainly in light of all the different changes that occurred during, following the 2021 legislative session. There was some suggestions though about, again, providing additional clarity, not just that an activity was going to occur, but identifying those start and end dates, or end times rather. Start times are practical and certainly something that we can incorporate. So we are going to amend this text, and I'll describe that here in a second. The end dates though, or end times rather, are not. The idea being that, again, if a certain number of ballots are received at the county level, and all the signatures go through the signature verification process, there are no issues or discrepancies that warrant duplication or any other factor, it's going to be a significantly different timeline than if the inverse is true, and every one of the signatures warrants curing, or again, there's other issues or concerns that take longer with the ballot. Therefore, Section 4, subsection 2 of this proposed regulation shall be amended to include the phrase, the published statement must include the anticipated starting time. More specifically, and to read it into the record, all of subsection 2 will now state, not later than 2 days before the date of delivery of the mail ballots to the Mail Central County Board of Counting, the county clerk must post a statement in his or her office that notifies the public that the Mail Central Counting Board will begin performing the actions set forth in subsection 1. And then we will add, the published statement must include the anticipated starting time. Again, so the public is aware of it and can plan on being there when that activity is about to occur. At this time, I will open public comment on proposed regulation R090-21P. If anybody's interested in providing public comment, please go ahead and indicate so in Zoom now. All right, I don't see any public comment on proposed regulation LCB file number R090-21P. Okay, seeing no further public comment, well, I'll close public comment on proposed regulation R090-21P. Proposed regulation LCB file number R090-21P is adopted with the changes as mentioned on the record and will move forward to the Legislative Commission. We'll now open the adoption hearing on proposed regulation R091-21P. Existing law requires the Secretary of State to adopt regulations for the conduct of elections in the state, which must include regulations prescribing 1, the procedures to be used to ensure the security of the ballots, 2, the procedures to be used to ensure the security and accuracy of computer programs and tapes used for elections, and 3, the procedures to be used for the testing, use, and auditing of a mechanical voting system. Sections 1 and 10 of this regulation require each county clerk and city clerk to submit to the Secretary of State a written contingency plan for 1, election operations in the event that election operations are significantly disrupted, and 2, the tabulation of ballots in the event that the county or city, as applicable, experiences a loss of central counting equipment or the use of the central counting place. Existing regulations, 1, define the term ballot stock to mean the material upon which a ballot is printed and a voter directly indicates his or her vote. 2, provide that the Secretary of State will reimburse the counties for the cost of the basic stock for ballots. 3, require a city clerk to order ballot stock for an election within 2 days after the date set forth for the close of registration for the election. Sections 2, 8, and 11 of this regulation provide that the term ballot stock also includes the materials included with a mail ballot, including without limitation, the mail ballot, return envelope, privacy sleeve, and voter instructions. Section 3 of this regulation replaces the term stock for ballots with the term ballot stock. Existing law requires a county or city that wants to change or improve a mechanical voting system or mechanical recording device to first obtain approval from the Secretary of State. Section 5 of this regulation prohibits the county or city clerk from installing any software on a mechanical voting system unless the Secretary of State has approved or required the installation. Section 6 of this regulation requires each county clerk and city clerk to maintain a written documentary record for mechanical voting systems, mechanical voting devices, and other voting equipment, which includes the records of transports of mechanical voting systems, mechanical voting devices, and other voting equipment, and chain of custody records for mechanical voting systems, mechanical voting devices, and other voting equipment. Section 6 also requires mechanical voting systems, mechanical voting devices, and other voting equipment to have tamper-evident seals identified with serial numbers, which must be recorded and verified in the records of the county and city clerks. Section 7 of this regulation requires each county clerk and city clerk to keep mechanical voting systems, mechanical voting devices, and other voting equipment in a secure and controlled facility when not in use, and to maintain a record of any person who accesses the mechanical voting systems, mechanical voting devices, or other voting equipment. If there's any unauthorized access, Section 7 requires the county or city clerk to inform the Secretary of State in writing within 24 hours. Existing regulations require that each county clerk, not later than the 90th day before the primary election, submit to the Secretary of State for approval a plan concerning the procedures to be used to ensure the security of the ballots, results, cartridges, and VVPATs. Section 8 requires a plan to also include procedures to be used to ensure the security of election media cartridges or memory devices, blank ballot stock, chain of custody records, and access controls. Section 8 further requires the county and city clerks to ensure that election board officers who are allowed to handle ballots, results cartridges, and VVPATs have sworn under oath to perform their duties honestly and faithfully. Existing law requires a copy of each election computer program to be filed with the Secretary of State at least 1 week before an election. Section 9 of this regulation requires that the copy be filed in certain electronic formats with password protection. There were no proposed changes to this proposed regulation, the text of this regulation. At this time, I'll open public comment on proposed regulation R091-21P. If anybody is interested in providing public comment on proposed regulation R091-21P, please go ahead and indicate so in Zoom now. Okay, unless there's anybody that wants to speak, that will no public comment on this proposed regulation. Okay, I'll close public comment then, and on proposed regulation R091-21P. And see no public comment, proposed regulation LCB file number R091-21P is adopted and will move forward to the Legislative Commission. I will now open the adoption hearing on proposed regulation R092-21P. Existing law requires each county clerk and city clerk who uses an electronic roster not earlier than 2 weeks before, not later than 5 p.m. on the day before the first period for early voting by personal appearance, to complete a test of the electronic roster to ensure its functionality in accordance with regulations adopted by the Secretary of State. This regulation requires the county or city clerk to also complete logic and accuracy tests on the electronic roster to certify to the Secretary of State that the testing was completed not earlier than 2 weeks before and not later than 5 p.m. on the day before the first day of the period for early voting by personal appearance. The tests required by this regulation require confirming: 1, the electronic roster accurately displays certain information; 2, the correct functioning of the electronic roster in certain situations; and 3, the correct performance of certain functions of the electronic roster. Now, there was also, again, significant feedback relating to this proposed regulation. Again, though, the idea here, though, is that as we are now establishing the testing requirements for our electronic rosters, and not understanding necessarily the full scope of the work that will be required by the counties and city clerks. These are an initial step, but again, a very deliberate, regulated step based on previous experience conducting similar type tests with other machines. Going forward, though, certainly looking to, again, continue to enhance and refine what these tests look like. So there's a very solid chance that these may be changed again in future regulatory reviews. But as it stands right now, there will be no changes to the proposed text. At this time, I will open public comment on proposed regulation R092-21P. If there's anybody that wishes to speak, please go ahead and indicate on Zoom now. Okay, not seeing anyone interested in making public comment on proposed regulation R092-21P. Hearing no public comment, I will close public comment on proposed regulation R092-21P, and proposed regulation LCB file number R092-21P is adopted and will move forward to the Legislative Commission. At this time, I will open the adoption hearing on proposed regulation R093-21P. Existing law requires the Secretary of State to adopt regulations relating to elections. Existing law provides that it is unlawful during early voting or on election day to electioneer inside of a polling place or within 100 feet from the entrance of a polling place. Existing law also requires the county and city clerk to ensure that certain notices relating to electioneering are posted at the outer limits of the area within which electioneering is prohibited. Sections 2 and 11 of this regulation interpret the term polling place for the purpose of such electioneering statutes as meaning a place designated by the county or city clerk for the purpose of voting by personal appearance. Existing law authorizes an Indian tribe to submit a request to the county or city clerk for the establishment of ballot drop boxes within the boundaries of the Indian reservation or Indian colony for the day of certain elections. If the county or city clerk establishes such a ballot drop box, existing law requires that the county or city clerk to continue to establish the ballot drop box for the day of any future primary election, presidential preference primary election, or general election, unless otherwise requested by the Indian tribe. Sections 3 and 12 of this regulation require the request for the establishment or removal of the ballot drop box within the boundaries of the Indian reservation or Indian colony to be submitted to the county or city clerk on a form prescribed by the Secretary of State. Existing law establishes various requirements relating to ballot drop boxes. Sections 4 and 13 of this regulation require the county and city clerk to affix each ballot drop box with a unique identifier in the county or city seal or similar design that signifies the box is an official ballot drop box of the county or city. Sections 5 and 14 of this regulation require the county and city clerk to submit a list to the Secretary of State of each ballot drop box established in the county or city. Sections 5 and 14 require the list to include 1, the unique identifier of the ballot drop box, 2, the location of the ballot drop box, and 3, the dates and times during which the ballot drop box will be unlocked and accessible for ballot submission. Sections 5 and 14 also require the county and city clerk to submit an amended list to the Secretary of State not later than 24 hours after a change is made to the information contained in this list. Sections 6 and 15 of this regulation establish various provisions relating to the security and accessibility of ballot drop boxes. Sections 7 and 16 of this regulation require the county and city clerk to submit a plan to the Secretary of State that relates to the ballot drop boxes that are tampered with or rendered inaccessible. Sections 8 and 17 of this regulation require the county and city clerk to establish retrieval teams for the purpose of collecting and transporting mail ballots from ballot drop boxes or the receiving center to the central counting place as directed by the county or city clerk. Sections 8 and 17 also establish a time frame in which such retrieval teams must collect the mail ballots from the ballot drop boxes. Finally, sections 8 and 17 require the retrieval teams to submit a form to the Secretary of State which describe the chain of custody of the mail ballots collected from the ballot drop boxes. Sections 9 and 18 of this regulation require the county and city clerk to submit a report to the Secretary of State not later than 45 days after each general election. Sections 9 and 18 require the report to include the costs associated with purchasing, installing, and performing maintenance on the ballot drop boxes and to the retrieval teams. This is another regulation that received feedback relating to the proposal of tripartisan ballot retrieval teams in mandating tripartisan ballot retrieval teams. Currently, again, just as a reminder, regulations require bipartisan as practicable. But again, this is something that we are going to conduct an analysis of to see if it's feasible through the 2022 election cycle. As such, there's no other identified changes, or there are no identified changes to proposed regulation R093-21P. At this time, if anybody is interested in providing public comment relating to proposed regulation R093-21P, please go ahead and indicate so in Zoom now. Is there anybody interested in making a public comment relating to proposed regulation R093-21P? Seeing no hands raised, and hearing no public comment, I will close public comment on proposed regulation R093-21P. Proposed regulation LCB file number R093-21P is adopted and will move forward to the Legislative Commission. This time I will open the adoption hearing on proposed regulation R094-21P. Existing law requires the county and city clerks to mail each active registered voter and each person who registers to vote or updates his or her voter registration information not later than 14 days before an election, a mail ballot for all elections. Existing law also requires establishes certain procedures for processing and counting mail ballots received by a county or city clerk, and 2, authorizes a county or city clerk to process and count mail ballots by computer or other electronic means. Sections 2 and 5 of this regulation require, beginning on the first day of the period for early voting, each county and city clerk to 1, count all return envelopes returned by mail in person at the clerk's office or deposited in a mail in a ballot box, 2, batch the return envelopes, and 3, record the total number of return envelopes received. Sections 2 and 5 further require each county and city clerk to forward any return envelope received for a different county or city to the county or city clerk of the correct county or city. Sections 3 and 6 of this regulation require the county or city clerk to 1, perform periodic audits of employees in the clerk's office whose regular duties involve checking signatures on mail ballots, and 2, if the county or city clerk uses an electronic device to sort mail ballots or capture a digital image of a voter's signature, to test the electronic device before it is so used to ensure the electronic device is able to properly sort mail ballots or clearly and accurately capture the digital image of a signature on a mail ballot as applicable. There was also, again, some very creative and frankly, good suggestions that were provided relating to this proposed regulation. A lot of these, though, again, are going to warrant further analysis during this election cycle for a number of reasons, especially as we all discussed before, making sure that we're not overburdening the clerks. There are a number of things also relating specifically to increases in public transparency and the posting of information available to the clerks that we're going to consider and attempt to do during this election cycle to see if, again, it's practicable. And then based on that, we're going to provide some feedback to, or rather, then we'll take that feedback and apply it into future regulatory cycles. All right, so that being said, again, there are no proposed changes to the text for proposed regulations R094-21P. At this time, I'll open public comment on proposed regulation R094-21P. At this time, if you are interested in providing public comment on proposed regulation R094-21P, please go ahead and indicate so in Zoom now. Okay, I don't see any indication of folks interested in making public comment on proposed regulation R094-21P. So we'll close public comment on proposed regulation R094-21P. Proposed regulation LCB file number R094-21P is adopted and will move forward to the Legislative Commission. I'll now open the adoption hearing on proposed regulation R095-21P. Existing law 1 requires a county and city clerk to establish procedures for the processing and counting of mail ballots, and 2 authorizes a county and city clerk to review the signature of a voter on a mail ballot manually or by electronic means. Sections 2 and 5 of this regulation provide that an electronic device used in an election to verify signatures on mail ballots may only be connected to computer network for maintenance and support, and such a computer network must be closed, secure, and behind a firewall. Sections 2 and 5 further require that the county and city clerk keep maintenance logs documenting certain information regarding maintenance performed on an electronic device. Existing law provides that if a county or city clerk uses an electronic device to verify signatures on mail ballots, the clerk must 1, conduct a test of the accuracy of every electronic device before the election, 2, perform daily audits of the electronic devices during the processing of ballots for the election, and 3, prepare an audit report. Sections 3 and 6 of this regulation set forth requirements for the daily audit of an electronic device used to verify signatures on mail ballots. Sections 3 and 6 provide that if during the daily audit and manual review of signatures verified by the electronic device results in a signature being rejected by the auditors that was verified by the electronic device fails the audit, and the county or city clerk must stop using the device immediately and notify the Secretary of State. Feedback relating to this proposed regulation also included increasing transparency and discussion of the release of records to the public as soon as possible, along with increases in the audit percentage all of which are, again, under further consideration and requires that analysis going into this legislative session. There was also discussion about mandating, again, the tripartisan versus bipartisan involvement in this process. Again, and as stated before, these are things that we're going to look closely at during the 22 election cycle to see if it's possible to incorporate during subsequent regulatory reviews. That being said, though, there are no changes to the proposed text for regulation R095-21P. At this time, I will open public comment on proposed regulation R095-21P. If anybody's interested in making public comment on proposed regulation R095-21P, please go ahead and indicate so in Zoom now. Okay, not seeing any interest in public comment on proposed regulation R095-21P. I will close public comment on proposed regulation R095-21P. Proposed regulation LCB file number R095-21P is adopted and will move forward to the Legislative Commission. At this time, I will open the adoption hearing on proposed regulation R096-21P. Existing law authorizes a county or city clerk to create such boards and appoint officers as the clerk deems necessary for the expeditious processing of ballots. Sections 2 and 5 of this regulation authorize a county clerk and city clerk to create vote adjudication boards for the purpose of resolving the intent of a voter in casting a ballot if the voter selection in relation to a particular race or ballot question cannot be determined using a mechanical device or other electronic means. Existing law authorizes the county clerk and city clerk to create ballot duplicating boards, whose duties include receiving damaged ballots and preparing exact copies of damaged ballots so that the duplicated ballots may later be counted. Sections 3 and 6 of this regulation, 1, set forth certain procedures for a ballot duplicating board when duplicating a ballot, and 2, require each county and city clerk to submit for the approval of the Secretary of State a procedure for duplicating ballots before it is used in the county or city as applicable. Public comment related to this proposed regulation. Again, this is R096 for those following along. It did focus primarily on mandating tripartisan versus bipartisan involvement by observers and on the ballot duplication boards. Again, that is something that we're considering and will conduct an analysis of in the 2022 election cycle. But that being said, there are no proposed changes to proposed regulation R096-21P. At this time, I'll open public comment relating to proposed regulation R096-21P. If anybody is interested in providing public comment, please go ahead and indicate so in Zoom now. Again, just a reminder, if you do have a question, so that way the folks that are listening now or later are able to hear and understand what the question is, simply indicate that you have a question or public comment that you would like to make. I'll give you the floor, set my timer. I will read your name into the record, and that way we can make sure that we have your information for the record. And then again, you're able to state your comment or provide your feedback as necessary. All right, not seeing any indication that someone wants to speak for public comment. I will close public comment on proposed regulation R096-21P. Proposed regulation LCB file number R096-21P is adopted and move forward to the Legislative Commission. I will now open the adoption hearing on proposed regulation R097-21P. Existing law requires each county and city clerk to 1, prepare and distribute sample ballots for an election, and 2, ensure that a copy of each sample ballot is posted at each polling place. Existing regulations require that the county or city clerk prepare a sufficient number of explanations of the questions on the ballot so that, in relevant part, he or she can post at least 2 copies of the explanations in each precinct. Sections 3 and 10 of this regulation provide instead that the county or city clerk prepare a sufficient number of explanations of the questions on the ballot so that, in relevant part, he or she can post at least 2 copies of the explanations in each polling place. Existing law authorizes 1, the county clerk or city clerk to establish 1 or more polling places in the county or city as applicable, where any person entitled to vote in the county or city by personal appearance may do so on the day of the primary election, primary city election, general election, or general city election. And 2, any person entitled to vote in the county or city as applicable by personal appearance to do so at any such polling place. A polling place where any person entitled to vote in the county or city by personal appearance may do so is commonly known as a vote center. Existing regulations require that the county or city clerk, as applicable, prepare certain election supplies and equipment for each precinct, including at least 3 copies of each sample ballot which pertains to the election. Sections 4 and 13 of this regulation instead require that the county or city clerk, as applicable, prepare certain election supplies and equipment for each polling place. If the polling place is a vote center, the election supplies and equipment must include a means to print each sample ballot which pertains to the election upon request. Sections 2 and 8 of this regulation define the term vote center. Existing law requires each voting system used by a county or city to provide voting materials in English and certain other language as required by federal law or as authorized by the clerk. Existing regulations provide that if a procedure for bilingual voting is used in the county or city, each county and city clerk must prepare for each polling place certain required notices in the appropriate foreign language. Sections 5 and 12 of this regulation provide instead that if a procedure for multilingual voting is used in the county or city, certain notices must be provided in the appropriate foreign languages. Existing regulations provide that if a difference exists between the number of persons voting and the number of ballots cast in an election, the difference must be reported in writing to the county or city clerk as applicable, together with any known reasons for the difference. Sections 6 and 14 of this regulation provide instead that after the close of polls on the day of the election board must determine the total number of 1, persons who applied to vote and voted in person at the polling place, and 2, ballots cast at the polling place. If a difference exists between those numbers, the difference must be reported to the county or city clerk as applicable, together with any known reason for the difference. Sections 1 and 9 of this regulation provide a similar process for each day of voting during the period for early voting. Existing law requires a city clerk to appoint and notify registered voters to act as election board officers for the various polling places and precincts in the city. Existing regulations provide that if an election board of more than 3 members is required to accommodate the number of registered voters in any precinct, the city clerk may appoint as many additional members as he or she believes are necessary or desirable. Section 11 of this regulation provides instead that if an election board of more than 3 members is required to accommodate the number of registered voters who may vote at a polling place or in any precinct, the city clerk may appoint as many additional members as he or she believes are necessary or desirable. Existing regulations require that there be an adequate supply as determined by the city clerk of voting booths for each precinct. Section 15 of this regulation requires instead that there be an adequate supply of voting booths as determined by the city clerk for each polling place. Existing regulations provide that for a city election, if any polling place is closed early because all the voters registered in the precinct have voted, the election board is required to notify the members of the counting board of the closing immediately. Section 16 of this regulation provides instead that any polling place that is not a vote center is closed early because all the voters registered in the precinct have voted. The election board is required to notify the members of the counting board of the closing immediately. So in this, for this proposed regulation, R097-2MP, there's also, again, an increase in recommendations rather, that the regulation be modified to increase public transparency and to make certain documents available to the public as soon as practicable. That's also something that we're looking closely at, again, with the Secretary's guidance to increase transparency overall. We're still working through what exactly that will look like. One part in particular in this proposed regulation that stuck out, I think that maybe caused some level of concern, is how the reporting of the discrepancy between the number of persons voting and the number of ballots cast in an election, as the part of that audit that the clerks do. I do want to explain that part of that, again, is something that occurs in every election, where you have an instance oftentimes referred to as a fled voter, where an individual will come into the polling place, sign in at the front desk there. They will be identified as being an eligible voter. They will move up to a voting machine, and then for whatever reason, they won't vote. So we catch this at the county levels when at the end of the day, as part of that daily audit, they identify that 10 people signed in to vote, but only 9 ballots were cast on machines. That's a discrepancy, and that's exactly the sort of discrepancy that we've identified. The rationale behind that, the reasoning why an individual would be a fled voter, frankly, is something that there's not a lot of good answers on. Oftentimes, again, it's assumed that maybe they got a call or a text or had to leave in an emergency, maybe remembered that they had an event that they had to get to. Other times there could be questions about whether or not they, that they finished the process, again, out of concern, just left. There's a number of factors, but of course, it's hard to find individuals who admit to being a fled voter. These are things that we continue to look at to see if it is something, maybe a lack of clear instructions and the like. So we continue to work again with the really voting advocates across the country to identify best practices to make sure the instructions are as clear as possible and those sorts of things as well. But these are reports that again are provided to the Secretary of State that are available and that we are looking to increase the frequency that we either post them online or make them available to the public going forward. But there's still some question about how exactly to do that effectively. At this time, though, I will open up public comment on proposed regulation R097-21P after, again, stating that while we did receive some feedback, there are no proposed changes to this text. So at this time, if you're interested in making public comment on proposed regulation R097-21P, please go ahead and indicate so in Zoom now. Okay, I don't see any indication that folks are interested in providing public comment on proposed regulation R097-21P. Now, so this time I will close public comment on proposed regulation LCB file number R097-21P. Proposed regulation LCB file number R097-21P is adopted and will move forward to the Legislative Commission. This time I will open up this time I'll open the adoption hearing on proposed regulation R098-21P. Existing regulations authorize any person to observe the conduct of voting at a polling place in an area designated by the chair of the election board. The designated area must allow for meaningful observation, but must not be located in an area that would allow an observer to infringe on the privacy and confidentiality of the ballot of the voter. This regulation 1 clarifies that the term polling place includes a polling place for early voting and a vote center, and 2 defines the term meaningful observation. This regulation also authorizes the county or city clerk to limit the number of persons observing the conduct of voting at a polling place for reasons of public safety, or to preserve voter privacy or maintain order. This regulation we received a significant amount of public comment on and public feedback, all relating primarily to discussions about meaningful observation. Again, the goal here is to provide an improvement to the process, an initial definition of meaningful observation with an eye to the future and recognizing that we will likely need to continue revising this, not only the definition, but this proposed regulation through, again, in future regulatory reviews. Again, the idea here is to balance very carefully, as I just stated, individual privacy and confidentiality of the ballot of the voter and their personally identifiable information, along with the importance of transparency so that the public can see what's going on in the process. That being said, again, there are no recommended changes to this proposed regulation. At this time, I will open up public comment on proposed regulation R098-21P. If you are interested in making public comment on proposed regulation R098-21P, please go ahead and indicate so in Zoom now. Not seeing any indication that anyone is interested in making public comment on proposed regulation R098-21P. I will close public comment. At this time, proposed regulation LCB file number R098-21P is adopted and will move forward to the Legislative Commission. We'll now open the adoption hearing on proposed regulation R111-21P. Existing law authorizes the Board of County Commissioners of any county to purchase and adopt for its use at elections any mechanical voting system and mechanical recording device. A mechanical voting system is a system of voting whereby a voter may cast a vote, 1, on a device which mechanically or electronically compiles a total of the number of votes cast for each candidate, and 4 against each measure voted on, or 2, by marking a paper ballot which is subsequently counted on an electronic tabulator, counting device, or computer. Existing regulations require that the county clerk in a county using a mechanical voting system to conduct certain tests before and after each election to ensure that each mechanical recording device which directly records votes electronically will accurately record the votes cast for all offices and on all measures. Section 2 of this regulation requires that the county clerk also tests each ballot marking device, which is defined in Section 1 of this regulation as the device that allows a registered voter to mark a paper ballot, which is subsequently counted on an electronic tabulator, counting device, or computer. Existing regulations require that before each election cycle for federal office, each county clerk is required to certify that the operating systems installed on each mechanical recording device have been certified by the Voting System Certification and Laboratory Accreditation Program of the Election Assistance Commission. Section 3 of this regulation, 1, updates the name of the program and relevant citation to federal law, and 2, requires the county clerk to also certify the operating systems installed on each ballot marking device. Section 3 further requires these certifications to be done before each election. So this regulation was initially the subject of a workshop on January 21st, 2022, and an adoption hearing on February 3rd, 2022. However, it was adopted with language that conflicted with existing statutes. NRS 293B.150 sets forth the timelines for the testing required of mechanical recording devices and automatic tabulating equipment and programs. We therefore cannot put a different deadline in regulation for the testing of these devices. Now, this was identified immediately following the previous adoption hearing on February 3rd. So therefore, and more specifically, I'll read to you what NRS 293B150 says. It talks about tests required before the first day of early voting, not earlier than 2 weeks before, not later than 5 p.m. on the day before the first day of early voting. The county or city clerk shall test 1, the mechanical recording device, which directly records votes electronically, if any, or 2, the automatic tabulating equipment and program, if any, to ascertain that the device or equipment and programs will correctly count the votes cast for all offices and on all measures. Therefore, we will adopt the proposed regulation with the original text. That is something, again, the discussion and really the key feedback there was that up to the day prior doesn't allow time for the voting systems to be fixed. If there is a discrepancy identified. As I mentioned before, though, again, if there ever was a discrepancy identified, that voting system would simply not be used in an election. There would be no rush to get it quickly addressed or fixed in place. So again, therefore, we will adopt the proposed regulation with the original text that does not conflict with the existing statutes. At this time, I'll open public comment on proposed regulation R111-21P. If there's anybody interested in making public comment on proposed regulation R111-21P, please go ahead and indicate so in Zoom now. Not seeing any public comment on proposed regulation R111-21P. I will close public comment on R111-21P. Proposed regulation R111-21P is adopted as described and will move forward to the Legislative Commission. All right, at this time, I will open public comment on matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. Is anyone interested in providing public comment about a matter not on the agenda? If so, please identify yourself and spell your name for the record. Ms. Dermick, good morning.
Good morning. Hi, my name is Carrie Dermick, and I'm with Albany is Local, Nevada. First, I just really want to say thank you, Mark. I know this has been a very long process, and really, from our perspective, you've done such a great job. And so I really just want to say thank you, because I know that you don't hear that word a lot. So I just want to throw that out there. And then second, my hope is that after this process, voters like previously incarcerated voters, tribal governments, and Native American voters, and also voters that are currently in jail are, considered in these analysis and conversations that you're having throughout the year and throughout the future. I know not everything can be solved through this regulation process, but we just hope that we can have future conversations about some of the issues that these regulations have brought forth. And just again, thank you so much. And thanks for your consideration and time.
Yes, ma'am. Thank you for your involvement in the process as well. And for reassuring me that I wasn't on mute the whole time as well. I honestly kind of wondered if anyone could hear me, but at this time, is there anybody else interested in making public comment? Seeing none, I will close public comment on matters not related to this these proposed regulations. As a reminder, the adoption hearing today is not the end of the regulations process. Following the completion of this adoption hearing today, in fact, the next step will be the Legislative Commission on February 28th at 1 p.m. I'm copying the link into the chat again that you can take to get to the Legislative Commission's website that will provide the meeting information when it is available. Additionally, the Joint Interim Standing Committee on Legislative Ops and Elections is going to be convening here soon. They have 5 meetings scheduled over the course of the year between April 1st and August 12th. I'm going to copy that link into the chat as well. Again, if you're on here today and are interested in learning more about our elections or providing feedback into our electoral process, I encourage you also to keep a close eye on that website. Again, that is the Joint Interim Standing Committee on Legislative Ops and Elections. And that's the link there to all of those meetings. So again, the goal here is increased participation and awareness across the public sector so that you guys can maintain involvement in these processes and provide feedback to your representatives as appropriate. Otherwise, again, if there's no other comments, I do appreciate all of your time and involvement in these workshops and adoption hearings over the last few months. Again, anticipate very much that these will continue on, starting up and again, our regulatory review process will begin anew in January with an expected series of workshops beginning sometime mid to late summer of 2023 is as what we currently forecast. Otherwise, again, appreciate your time and attention. If there's anything that you have for me, please let me know via MD Elect, and I'll copy that in one last time just to make sure if anybody has it or has questions or concerns, they can reach out to me there. And then lastly, the recording of this video will be posted on our state webpage for individuals who have not heard it. You all, of course, are well aware of where that's at, but I'm going to copy the link into this chat as well. That's the page, the link to elections regulations, where you'll be able to see the video and the text as discussed earlier today. Otherwise, thank you all for your time, and we'll be in touch soon. Thank you.